I'd like to welcome in Austin Kennedy, Kevin Shannon of the Bryant Law Center for our today's edition of Local 6 Legal Line, and we're talking about personal injury. If you've got a question, we've got a number at the bottom of your screen there, 1-888-208-6946. And we have a question from Rachel already, who says, how does my health insurance get reimbursed if I was in an accident that was not my fault, but yet I have medical bills?
Well, if you're in an accident in Kentucky, then you're going to have what's called personal injury protection, or PIP, which is usually going to cover about $10,000 in your accident-related medical bills. If you ever exhaust that, your medical bills exceed $10,000, then you're going to have to put on your health insurance, whether or not that's Medicare, Medicaid, private health insurance. It depends on the type of plan it is, the type of health insurance. Medicare, for example, it's federal law. If they pay on your medical bills relating to an accident, which you recover from a third party, they're going to be entitled to 2/3 of whatever they pay on those medical bills. Generally, it's handled by your lawyer, if you have one, that will take care of negotiating the lien, making sure that they only cover bills that are related to your accident and not tacking on things that are clearly unrelated. Same way with Medicaid, except it's a state plan, state statute that governs it, and they're entitled to reimbursement as well, and they're going to assert their lien just like Medicare would, and they're going to be reimbursed 75% of whatever they pay. Private health insurance, it just depends. It depends if it's an ERISA plan or an employer-funded plan versus if you're just paying out of pocket for it. But usually I would say it's one of those things you definitely need to be talking to your lawyer about, making sure it's under control, making sure that you pay these liens back before you settle your case and disperse with the settlement proceeds.
This next question may be pointed at Kevin. He takes care of a lot of legal action with car accidents. As Steve says, I was in a multi-car accident. Who would I seek legal action against, since there were several drivers involved?
Well, those are very difficult, and they're very fact sensitive. The simple answer is you can only make claims against the drivers that were somehow negligent. The mere fact that there were multiple cars involved does not necessarily mean that every driver did something wrong. It could be that there was more than one person, because in Kentucky we're a comparative fault state, which means an accident doesn't have to be all one person's fault or all another person's fault. It can be some combination of those, but it really would just take a very detailed look at the facts, the driving circumstances, the legal obligations that each one of the drivers had, trying to determine whether they complied with those obligations or not.
If you have a question regarding personal injury, give us a call, 1-888-208-6946. We'll try to get it in before the end of this segment. We've got about a minute and a half left, and we do have a question from Marcia, who says, if my son was texting and had a serious accident, can they file criminal charges against him?
Well, I haven't seen this yet. It's a little outside our scope of personal injury as far as the criminals part goes. But what I would say is that there is a chance, I would say, that a prosecutor or the county or the state could press charges for wanton endangerment if you seriously injure somebody as a result of texting and driving. Typically, you're going to see that with DUIs or excessive speeding. I have not yet seen that with texting, but it makes sense. I mean, you're trying to deter people from that sort of conduct in the future. What better way, I guess, to start reinforcing texting and driving, kind of like you do drinking and driving, or exceeding the speed limit, 25 plus miles per hour over, where they can potentially charge you with wanton endangerment or something of that kind.
As far as texting and driving, is that easier to prove these days than what it was, say, maybe 4 or 5 years ago?
I mean, I guess it could be if you wanted to actually get in the phone, subpoena the phone records from the whatever provider that you have, AT&T, Verizon, whatever it is, and look at what kind of call log and text log and all that you have. But I think it's, for the most part, I don't think it's going to be done unless it is a real catastrophic injury case or a very serious criminal matter.
Austin Kennedy, Kevin Shannon will be returning for our second half of Legal Line. That'll come your way here in 20-25 minutes. If you have a question, go ahead and get